Strong employer-employee relationships are based upon a strong legal connection that can only be made from natural and necessary laws. What constitutes an employee-employer relationship in Israel? The labor court rules on disputes between an employee and employer. What is the legal significance of determining an employee-employer relationship? Types of employees in the State of Israel. An employee receives a salary based upon working hours. Independent contractor, fixed price with no hourly rate. A freelancer serves a particular client on a regular basis. The volunteers, unpaid work. And employees by virtue of the law, elected officials where the Knesset decides the salary, including soldiers and police officers. The forced labor, people who have received punishment involuntarily and work under duress. Prison inmates who work while serving their sentences are included. The work from home receives a salary but performs work remotely from home. The manpower contractor and services contractor are both forms of indirect employment. Each transaction is subject to different legal norms, therefore we must identify the nature of the working relationship to understand which laws apply. The distinction between each relationship is critical. The protective laws, e.g., minimum wage, hours of work and rest law, the dismissal compensation law, apply to only those who are legally employees and therefore are not applicable to a self-employed person who has entered into a contract. Section 24 of the Labor Courts Act provides a unique authority for the labor court to hear the claims of either an employee or employer against an employee. Thus, an independent worker will be taken to civil court. Two main questions arise in the case of a lawsuit. 1. What type of employee is the defendant or plaintiff? 2. Did the employee commit the offense? If it is found that the job operator is in the status of an employee, then the client of the work will immediately be considered an employer. To determine who is an employee, a number of auxiliary tests are used. Test of control and subordination. Firstly, the employer's control is examined. Did the employer have the right and the ability to control the employee's operation and supervise his work? Secondly, the employee's subordination is examined. Is the employee obligated to follow the employer's instructions, and does the employer see the employee as an employee? However, in some cases, this test is too conservative. For example, the majority of high-tech workers do not pass this test. Therefore, additional auxiliary tests were developed. Direct connection test. An employee has taken the responsibility to do the work himself. When he is absent from work, he is not obligated to find a replacement by his own initiative and at his own expense. Example of a case, Payment Devices Directive Ron v. Representation of the Common House. Rob was a gardener employed by a building committee by contact. When he was absent, he would bring a replacement. When the committee wanted to replace him, Ron demanded compensation. The committee never stated that Ron was the only worker and there was no personal connection between the committee and Ron. Additionally, because Ron found the replacement when he could not come to work, he did not constitute an employee. Tool supply test. Who provided the employee with the needed materials? The test proceeds from the premise that the employee provides the employer with the labor force and the materials are provided by the employer. Example of a case, an office that provides a computer and a desk for their employee who brings their personal computer has no change in employee status. However, in different instances, the status can change. Example of a case, if a truck driver drives his own truck, the status has the possibility of changing. The tool supply test is okay, but it is dependent on the circumstance. Integration test. This centralized test is suitable for most workplaces, yet it still does not address all circumstances. This test has two aspects, positive and negative. Positive. The tribunal examines whether there is a factory or workplace that can be integrated into it and whether the operator of the work has been integrated. It must be a physical place that the court deems a productive place. Negative. The tribunal examines whether the worker is an independent business owner who provides services to the enterprise as an external factor, even if he does integrate into the work. The tribunal says it could be that someone is truly independent but has integrated into the workplace, e.g., organizational consult. Questions to understand if a business or contractor is independent. Who benefits from job optimization and cost savings? Who invests and covers the means of production? Who profits from labor gains and who suffers losses? Who initiates and organizes the work? Hallmarks of an employee. The employee is not responsible for the physical workplace. The worker does not invest in the workplace with his own money. The employee receives a fixed wage and does not enjoy the workplace profits. The employee does not absorb the losses of the factory. The worker does not purchase new means of production with his own money. The worker has no economic interest in saving expenses or streamlining work. Mixed test. The mixed test was created as a result of Moore v. in the National Labor Court. In this PSD, Moore was the owner of an investigative firm and employed a private investigator, Angel, who was paid by portfolio while dividing the percentages. Angel would not meet with clients. He only performed the work. Moore even banned him from working for someone. After 7 years, the relationship between the two ended and Angel sought his rights, including severance pay. Moore objected and claimed that Angel was working as a freelancer. According to existing tests, could Angel be considered an employee? Angel won and Moore appealed to the Israeli court and loses. Moore files in the High Court and insists that there was no employer-employee relationship. Aharon Barak claims that there are extensive rulings that give auxiliary tests, but no one gave a perfect answer. In comparison to all the tests, the mixed test gave the best results. Barak explains that balances must be made. All of these require flexibility in the definition of the term employee. Moore lost, and it was determined that there was an employer-employee relationship. To conclude, the main auxiliary test today, an Israeli case, law for identifying an employee is the mixed test, centered on the integration test on the positive and negative side. However, this test is not independent and is used alongside the other auxiliary tests. Who is a freelancer? Tzedakah v. State of Israel, Gali Tzahel. Tzedakah was a correspondent for the Haaretz newspaper in London, and GLC wanted him to be their correspondent too. He agreed. GLC paid him for every article he produced. After nearly 8 years, GLC told Tzedakah that his services were no longer needed. Tzedakah insisted that he was their employee and sued them at the BAD with the intention that GLC would pay him everything he deserved. However, GLC claimed that Tzedakah was a freelancer. The Israeli court had to rule if there was an employee-employer relationship, and if there was, then Tzedakah was entitled to severance pay. The regional court rejected Tzedakah's claim and concluded that he was a freelancer. Tzedakah then applied to the National Labor Court and was unanimously accepted in that he deserves severance pay. The dispute remained if he was a freelancer or not. Judge Arad's approach, majority opinion, was to apply the same tests we know. They applied the positive and negative aspects of the integration test and concluded that Tzedakah was integrated within GLC. However, the court believed that this was a borderline case. President Adler, singularly, discusses the question of who constitutes a freelancer in Israel. Should the law recognize this type of work? Adler argues that Israeli law should recognize a freelancer, but in the industrial context. For example, if they are on social media, are they famous? Adler adds that the Israeli court should be careful when it comes to freelancers. Freelancer hallmarks. A person must have a profession, skill, or special knowledge, and the work cannot be manual labor. He works as long as he wishes. He decides who to work for. He can manipulate his income according to the amount of work he receives and performs. He has no fixed income. It can affect the volume of his expense in providing personal service. In conclusion, the court rules that a freelancer, if he has all the hallmarks of an independent contractor, is not entitled to the same protections as an employee. That is, if a freelancer does not work, his other definition does not matter. Legally, the definition of a freelancer does not matter. Hiring workers through contractors. In recent years, a mediator in the employment pattern has entered into a triple employment pattern. This model is also called the indirect employment model, outsourcing as a managerial strategy of the workplace. The organization buys the service from an external source, not through the organization's employees, but through someone else. It can bring financial efficiency as well as efficiency of specialization. An organization can focus on its interests, and the rest will be managed by the outsourced contractor. The goal is to reduce expenses and increase profits. The modular employment model is expressed in two formal forms. Employment through subcontractors. Subcontracts specialize in 1. The specific type of work. 1. The use of subcontractors is efficient and cost-effective. 2. Employment through personnel contractors. 1. Personal contractors specialize in recruitment in a variety of fields and not just in one specific profession. These companies serve as a kind of intermediary between the employer and the employees. Transaction through services contractor, informal. A service contractor in Israel specializes in providing a specific professional service. The service must be provided in the customer's place. The service is also not temporary. They have no employer-employee relationship. Hiring contractor workers. In 1996, the Israeli legislature decided to make an order and enact the law on the employment of workers by contractors 1556-1996. In 2000, the amendment was made into law. According to Section 12A of the Employment of a Contractor Employee Law, it is not possible to employ an employee for more than 9 months. For the first time, there is a definition of a temporary employee. If the employment period exceeds 9 months, the employee must be hired directly. What happened is that employers preferred to lay off employees to prevent direct employment. The law aimed to help the employed. Due to the ongoing harm to the contractor's workers, the law was augmented in 2011 to increase the enforcement of labor laws. The law is intended to protect workers, contractor workers in particular, while restricting employers. This ensures that the workers have rights. According to Israeli law, an employee who is outsourced and experiences a violation of his human rights must tell his initial employer, who then must contact the contractor. Despite many criticisms, employment through manpower companies and service contractors is legal in Israel. The employee's initial employer is, therefore, the manpower company or service contractor, except in outstanding cases where it is proven otherwise. Section 12A of the law stipulates that after 9 months of work, the client becomes the employee's direct employer. Working conditions become horrible when companies bypass service contractors. When employing professional workers is gaining momentum in the private sector. Accompaniment and legal representation from qualified and experienced labor law attorney. Shimon Hahn Law Office specializes in labor, civil, and commercial law. Shimon Hahn is also very experienced in real estate, litigation of neighbor disputes, lawsuits, inheritance, wills, and more. Our firm provides personalized legal services to our clients and ensures full assistance in the process of filing claims with labor courts. Our experienced labor law attorneys collect and formulate testimonies and evidence. They use proper conduct before the responsible and relevant parties and represent in mediation proceedings and in all courts until the desired result is achieved, all while preserving the client's important interests and rights.